8. Welcome back to Sunrise Daily. Well, we'll start off today with where we did leave off yesterday, looking at the judgment of the Abuja High Court. Well, we're joined this morning by Mr. Lai Mohammed, who is the Interim National Publicity Secretary of the APC. Morning, and thank you for coming on today.
Good morning.
Well, we've seen some of the headlines already, the response from the party concerning that judgment. But yes, indeed, you say that that judgment was wrong. Just for those who might have missed it, give us a background, your perspective on this judgment.
I think the media, to a great extent, is probably to be held responsible for the confusion. You see, if we had a judicial correspondent who is well trained, we wouldn't have the kind of headlines we had. You see, in law, in a judgment, there are two components. There's what we call the holding or the orders. It's what we call the obiter. It's only the holdings of a judge. When the judge says, I hold, or I give the following orders, that is the enforceable part of the judgment. The obiter is an advice. It's not enforceable. And in this particular situation, the judge gave 3 orders. But before he got to the order, he did advise, he gave personal opinions, unsolicited. But the cardinal thing in law is that a judge can only determine matters before him. What was the matter before Justice Ademola? It was that the PDP went to seek certain reliefs. That one, that the leadership in the House of Representatives should not be changed, and that the 37 defecting legislators should not be allowed to participate in any motion or debate leading to the leadership changing the House. So the issue of whether the defecting legislators had the right to do so or not was not before him. So he had no business pronouncing on them. But of course he knew this, and that's when he gave the orders. He gave only 3 orders. 1, there should be no leadership change in the House. 2, that the defecting legislators cannot participate in any debate or motion leading to leadership change in the House, and a perpetual injunction restraining them from doing so. He never gave an order saying that the defecting legislators should resign or vacate their seats.
Okay, so all those headlines that were in the papers about asking them to vacate their seats should not have been. It was not even given in the first place.
Absolutely. But more than that, we also believe that even the judge himself had no business discussing or advising or sermonizing. It was not before him.
So why would he do it if...
I think this is exactly why we said we're worried, we're concerned, because it's unethical and it's unprofessional.
Yeah, but if he is not competent to do that and he's done it, and it's out there the way it is, if they had not appealed the case or for stay of execution, it subsists, doesn't it?
No. You see, you only enforce orders. You enforce judgment. You don't enforce advice.
So that one was in the realm of an advice.
Absolutely, yes. And what we appealed against was not the order that they should vacate their seat, because there was no such order. What we appealed against is the perpetual injunction restraining those legislators from participating in motions and debates, leading to leadership change. Because these legislators have been elected by their various constituencies precisely to participate in debates and motions in the House.
Well, what is your take? I mean, because you have said that the judge had no business. Some people might disagree with you because they will look at the matter and say that they are very closely related. the PDP went to court to seek those reliefs because they felt that if they didn't act on time, then possibly something very drastic could happen. If the judge was given a judgment or an advice or an opinion based on a related matter that was before him, some people would say it's very much in order that ideally, the lawmakers should have resigned their seats. They ought to have resigned, if I remember that's the language. They ought to have resigned their seats honorably, as it were. Some people say that is very much in order.
Look, we were talking about law. We're saying that when you go to court, you seek certain relief. You can't be given what you did not ask for in law. If PDP went to court to ask the court to give them a relief that the leadership in the House should not be changed, they knew that's what they asked for. They wanted to ask for defected legislators to vacate their seats. They could have done so. They are still free to do so. But no judge will give a litigant or a plaintiff a relief that is not sick. And you don't consider, you only consider what is being canvassed before you. It's straight law.
He has. He's given orders to that effect. But you cannot deny him his opinion.
Oh, of course not. But like we say, his opinion, what is unsolicited, it's not binding. And it's of no effect. And it's unenforceable. Yes, I agree with you.
Are you uncomfortable? Is the APC uncomfortable only and simply because they're being painted in a bad moral light?
How are we being painted in a moral bad light? How are we being painted in a moral bad light?
It's a matter of honor, isn't it? In the sense that if he says that they ought to have resigned honorably.
Incidentally, we're talking about a matter of law here. It's a matter of moral. It's about a matter of law. At times, moral and law, there's a kind of convergence. But not everything that is moral is legal. Not everything that is legal is moral. We're talking about law.
But he even went and cited Section 681G of the 1999 Constitution. I think
precisely that, but it's not before him. That's what I'm saying. It's simply not before him. It's like if you go to court, you say you reporting your landlord, or that your landlord ought to not have rejected you. What is the business of the judge about the matrimonial problems with you and your landlord?
So does that mean if it's not before him, he cannot look into it?
No, he cannot. That's straight law. Because, you know why? Because you see, if a matter is not before you, you can't canvass. You see, you cannot argue for or against it. Now, if PDP wants the lawyers, if the PDP wants their members who defected to vacate their seats, they should go to court and file a motion saying that these defecting legislators should vacate their seats. Then our lawyers then will know what argument to also counter them with.
Mr. Lai Mohammed, is the APC afraid?
Of what?
Because the Constitution, going by the Constitution, the electorate did not vote the individual lawmakers. They voted the party that brought them in. So how is it that they are still insisting on staying in there?
No, see,
if they've defected
now,
to another
see,
party?
let's go to the issue. You see, if you want us to go to the section 68, that's a different ball game. And I can sit here today and argue that even if that was before the judge would have erred in law to even have said that there's no faction within the PDP. What does Section 68 say? Simply says that the only condition under which a legislator elected on platform of one party can defect to another party without losing his seat is if there's a division within his party. Now, the issue of division within PDP, I don't think it's rocket science to know that there's a division within PDP. If there's no division within PDP, why would 7 governors in PDP walk out of their mini convention on the 31st of August 2013? There was no division within PDP. Why would 5 of their governors leave the party and join APC? There was no division within the PDP. Why would the crisis in PDP that led to the resignation of their chairman have happened? Now, if that's what we want us to prove in court, we have ample evidence to prove that.